next case to come before the court is City of Akron v. Andrew Walls. You will each have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, as I'll be keeping track of the time. Hopefully everything will go right with the clock here. The arguments are being recorded, so please keep your voices up and introduce yourselves. Don't use the names of minors or victims or children. Should that be relevant to your case, you can refer to those folks by initials or terms like the child. We have read your briefs, and we're ready to proceed when you are, and I would just ask appellant, would you like to reserve time?
I just reserve a minute or two.
Okay, I'll put you down for 2.
Thank you, Your Honor.
You may proceed when you are ready.
Thank you, Your Honor. May it please the court. It's a pleasure to be in the courtroom this morning. This is somewhat nerve-wracking for me. This is the first time I've done this actually as a licensed attorney, and I've done this once before as an intern.
Well, welcome.
That being said, Attorney Larry Spaljarek, on behalf of Mr. Walls, I'm standing in for my law partner and co-counsel on this matter, Andrew Wides. Your Honors, the issue before the court and the subject of the brief in this appeal is an abuse of discretion by the trial court judge upon sentencing of my client, Andrew Walls. It's kind of it is a two-pronged appeal, Your Honor, and the issues that we raised are these. One, that the judge in this matter did not apply the tenets of law, specifically the sentencing guidelines under, the applicable sentencing guidelines under 29, 29, 21 through 27, as it applies to the facts of this case. The statute, sentencing guidelines, generally speaking, require the court to consider appropriateness of jail under certain applicable substatutes and appropriateness of community control sanctions. In this matter, the judge she sentenced my client for, he was originally charged, I'll back up, I know you've read the briefs, but just a kind of short summation, my client was charged, I was the only person charged out of a bar fight in Highland Square. He was charged originally with 2 counts of assault. Ultimately, through Rule 11 negotiations, my client pled to 1 count of simple assault and 1 count of disorderly conduct with persistence. That said, the sentencing guidelines, generally speaking, when it addresses the Ohio Revised Code, looks at misdemeanor sentencing guidelines for misdemeanor infractions where the imposition of a maximum jail sentence is to be imposed, 29, 29, 24 specifically. The court's tasked with looking if the offender committed the worst form of the offense. I would argue that an assault is assault. I'm not trying to diminish that in any capacity, so please do not take my words as trying to do that. But in this matter, it wasn't a felonious assault, and it was not a hate crime, though through the progression of the case, there were attempts to try and sensationalize it through the media and try and portray this as a hate crime, which through negotiations with the state of Ohio, the investigation conducted by the FBI, it was early on determined that this doesn't rise to the level of a hate crime in any respect. So it maintained 2 counts of simple assault. 29-24 also conjunctively says that the judge must conduct or the conduct or the response of prior sanction for prior offenses require the imposition of a maximum jail term as necessary to deter the offender from future crimes. I think it's fair to say that 29-24 doesn't apply in this circumstance when imposing the maximum jail sentence, because my client never had a record. There were no prior offenses, and there certainly have been no offenses since this matter. So the application of 29-24, I think, wouldn't even apply. The sentencing guidelines, Your Honors, under 29-22 to determine the appropriateness of a sentence for misdemeanors, it says that the court shall consider the following factors, and I'm sure that you're all very aware of these, so I'll go over them very briefly.
Can I ask a question?
Absolutely.
Is there anywhere in the record where she actually says silence, she's using silence, him not speaking about the offense as a factor? Because the quote that I read from the briefs that quoted the transcript said that she's looking at the PSI and didn't find any remorse within this PSI. Is there any using silence as a factor?
What she did say, and I'm going to the transcript, she said she was looking for something, to see if there was any introspection there. Introspection implying remorse in that context. The actual language saying that that the silence specifically did not rise to the level of, his silence didn't rise to the level of introspection or remorse. She didn't specifically say that because he said nothing. She implied that up until the point of his allocution, if you will, which is the first opportunity he's had to really address the victims in this case, and to address the court, and to take responsibility for the actions for what he did on this particular evening. The transcript reflects that he was very remorseful, and he took that opportunity at that time. But the judge prior to that indicated that she was looking for something that allows her to see whether the person was remorseful and take responsibility for the action, so that's that's an important factor in considering the appropriate sentence. That she found none, and that whether she appreciated what he had said on that day prior to, there was nothing that would indicate remorse in any respect. That said, the courts have to take nature and circumstance of the offense. Again, this is a simple assault, not a hate crime, not a felony. Again, not trying to diminish the seriousness of an assault charge. History of criminal activity. Again, my client has zero record. Circumstances of the offense which indicate the offender was a risk to others, or conduct of a repetitive pattern. Again, no record, no repetitive pattern, no metric by which to determine that there was going to be any possibility of recidivism. Whether the victim's age, youth, disability, or any factor makes her particularly vulnerable. The facts of the circumstance was it was a bar fight that didn't involve the victim. She and her friends were out in an evening. They were bar hopping. She indicated they walked upon the fight. The victim here, she interposed herself to some degree, which ultimately led to her being assaulted by my client. I don't believe that any other factor it would rise to the level of making her more vulnerable, or there were no disabilities that were made noteworthy, or at least that we were made aware of. So I would say that other than wrong place, wrong time, that nothing makes her particularly vulnerable. 5, whether offender is likely to commit future crimes. I don't believe there was any indicia of that, and whether he had any physical or traceable anomaly, mental or physical anomaly to armed services, service in the armed services. He does not have any military experience. Again, when indicating what the judge considered for prior to sentencing, she was looking for introspection. Nowhere in the guidelines for the sentencing was introspection a requirement. But she seems to, based on what she said on the record that day, it seems to indicate that that was the overarching or the driving fact behind levying such a harsh sentence. The second issue, Your Honors, is my client has an inalienable right to remain silent. So up until that point, my client, whether it be through advice of counsel or his own knowledge of the Constitution, is instructed not to talk about the case. The lawyer's job, obviously, is to defend and at certain times mitigate or negotiate. The Rule 11 negotiations in this case, it yielded an amendment from one of the assault charges to a disorderly conduct. He pled to the other, indicating that he, admitting to guilt in that respect. And there was a charge dismissed for weapons while intoxicated charge, but there was no evidence at any point in this case that would indicate that the state had proved that and there was no weapon involved. That said, again, introspection is what the judge used. In addition, she indicated to the PSI she was looking for something that allows her to see if he was remorseful. His silence was protected by the Fifth Amendment. It's just a simple argument. And that case law, Supreme Court jurisprudence indicates that one's silence up to the time that they decide to speak unfettered they should not be held accountable for their silence, that they should not be punished for simply exercising their constitutional rights. So that being said, Your Honors, again, it is our contention that the judge misapplied the sentencing guidelines for somebody who, in my opinion, and the opinion, I believe, of probation, or at least of the general consensus was he was definitely probationable. There was nothing that would indicate otherwise. The legislature, again, has specifically itemized or spelled out the factors that generally the judge should look for when levying a sentence. And second, that my client's inalienable right is not indicia of a lack of remorse. And again, the first opportunity my client had, he indicated to the victim, but the victims who were present on the day of sentencing, that he was very sorry for what happened, and he took full responsibility for his actions. And in the intermediate period of time, he was on a scram bracelet because it was an alcohol-related crime, no violations. Probation indicated that he was more than compliant. He took it upon himself to not only do psychological counseling, because my client is a gay male, which was kind of the subject matter of what initiated the fight, but not relevant to the victim's involvement in this matter. But, for years of depression and anxiety that he suffered with his, just who he was, in dealing with that particular factor, he took it upon himself to undergo psychological therapy as well as substance abuse counseling, which he still continues to today. Again, I would just iterate that he does not have any record prior to or since. He was completely compliant with the process the entire time. And again, the first opportunity my client did express with heartfelt sincerity that he was remorseful what had taken place. That said, we would ask the court to remand this matter for resentencing. Thank you.
Thank you. You will have your full 2 minutes for rebuttal.
Thank you, Your Honor.
Good morning, Your Honors. Brian Bremer on behalf of the City of Akron. Von J. Brown is here with me today as part of this appeal. I wanted to alert the court to an issue that has arisen since the briefs were filed, which is that Mr. Walls has served his entire jail sentence. So the 180-day prison jail term is basically a moot point now. And the relevance of that in my mind is the fact that that jail sentence was the maximum, and that seems to be the driving concern in the appeal. There's not a lot of discussion about the $250 fine that was imposed or the length of community control in either of the two cases. Because there are two cases here, despite the case being consolidated. There was one involving one victim, and there's another one involving a separate victim. And so the sentence has already been complete as far as the jail term. And I think that colors a lot of when we evaluate like what the court did. What the court did is in imposing a $250 fine and ordering Mr. Walls to go to Alcoholics Anonymous counseling doesn't seem to be out of line with anything involving the misdemeanor sentencing guidelines. And in fact, I would say that the jail term itself was justified, but like I said, I think it's moot at this point. And I agree also with counsel that there are two prongs to this appeal. The first one is the issue that he's raising about the right to remain silent, and the second one is about the general misdemeanor sentencing guidelines. The first one is a fairly straightforward issue, which is that in State versus Brunson, the Ohio Supreme Court said if you don't object at sentencing, you forfeit all the plain error on appeal. That case is cited in both parties' briefs in this case. And in this case, at the actual sentencing hearing, Mr. Walls did not object to anything the court was saying about the remorse or lack of remorse that she was seeing in the record. So it is the city's position that that Mr. Walls forfeited all but plain error, and then this court's precedent is fairly clear, which is that if plain error is appropriate, it needs to be argued, and that this court will not develop an argument on behalf of the appellant.
Just for clarification, didn't object to that point, or didn't object to the entire sentence, no objections whatsoever?
I do not believe there was any objection at the sentencing hearing on about the Fifth Amendment right or about the sentence itself. And the Fifth Amendment right would be the more important issue for that portion of the appeal. But even assuming this court wanted to address the plain error issue head on, and even assuming that there was an issue, what the court did amounted to legal error and that the error was plain by talking about a lack of remorse on the record. The outcome of the sentence would not be different based on the record that was before the court here. At least not but for that consideration of lack of remorse. And the reason that is so is that the court emphasized Mr. Walls' behavior in discussion in the sentencing colloquy. The court emphasized that she found his behavior egregious, reckless. The court pointed out that he used hateful language. The use of racial and derogatory slurs. I don't want to say hateful, that she didn't use that word, but she said racial and derogatory slurs is hurtful in and of themselves, but to use them along with violence is just reprehensible and should never be tolerated in our society, in our community, and I just can't tolerate it in this court. She's not discussing his lack of remorse the lack of remorse is discussed, but it is not like the driving factor here. The driving factor is Mr. Walls punched one of the women so hard that he split her lip after calling her a racial slur and a sexual gender slur. The court was well within its discretion to decide that the misdemeanor sentencing guidelines support a 180-day jail sentence, the maximum under the circumstances here. The court was well within, and again, that's been served. The court was well within its rights to impose a $250 fine, not going all the way up to $1,000 the court could have. The court was, again, that's well within its discretion, well within the guidelines, and also the court imposing community control to try to ensure Mr. Walls gets the help he needs to be rehabilitated, which he admitted he had an alcohol problem. And yes, he did attend Alcoholics Anonymous for some time after the events. But the court noted on the record that he stopped attending in July and then didn't attend in August, September, and then only began attending again when he pleaded guilty. So and the court kind of pointed out that yes, you started attending, then you stopped, and then the moment you came back in and said, I want to try to be good for my sentencing, you started up again, which would imply some lack of sincerity, I think, that the court was tapping into when it pointed that out and reviewed that in the PSI. And all these together does not make it an abuse of discretion to require community control and to require the fine, and the jail sentence was justified as well, regardless of whether or not you consider the discussion about lack of remorse and whether that somehow violated his Fifth Amendment rights. Because, like Judge Lansinger pointed out, the reality is she doesn't come out and say, the judge never says, I know you have a right to remain silent, but I'm really thinking that's like, you should have come out and said something. The court just points out, I don't see anything here to really show that you're remorseful. And I think in some ways that's what the Alcoholics Anonymous discussion is about as well, is the fact that if you were truly remorseful and you thought you needed to get help, you'd be taking actions all the time as opposed to just taking them for some point of time, dropping off, and then trying to reassert your behavior and your remorsefulness after you plead guilty. And that's what the court was looking at. Under the circumstances here, it was not an abuse of discretion for the court to issue the sentence it did, and therefore there's no way to demonstrate on this record that but for the consideration of the Fifth Amendment right to remain silent, the sentence would have been different. Because again, the only sentence that was at a maximum was the jail sentence, and that was justified by the violence, the speech, and then also the fact it's already been served. So it's a good point. I'm happy to address any issues the court may have, but otherwise I would just respectfully request that you affirm.
Any questions?
Thank you, Your Honor.
counsel. You'll have your full 2 minutes.
Thank you. To address a few things that counsel indicated, the 6-month sentence has already been served. I recognize the mootness of that. It is the 2 years of community control sanctions in addition to from the other charge that on the heels of that would necessarily be a point of contention at this point in time. Most of that falls in large part based on docketing and time frame.
Can you clarify that? Because there was something about the
It is the same same facts and circumstances. I believe it fell under the one case number. And again, the Rule 11, there was an agreement with the state of Ohio that sentencing would, that the sentences would merge because they came out of the same facts and circumstances, which the judge obviously deviated from that.
So the case that was appealed was the assault, that case, but.
I believe they were under the same case number, if I'm not mistaken.
I didn't know, I just didn't know the answer to that. There was some talk.
No, I'm sorry. Both case numbers are listed. Both case numbers are listed. There are two different case numbers.
Thank you.
And again, the council raised the issue of racial slurs that the judge indicated in there. Again, it's protected speech. It was not determined to be hate speech in any way, and that it was certainly not a factor for consideration for sentencing on the day of sentencing, but the judge indicated that it wouldn't be tolerated in her court, and therefore he received the maximum sentence. Council also brought up the issue that the victim was hit so hard that split her lip. It's difficult to discern at any point during this case if the injury she suffered was from when my client did hit her, or the 5 to 7 times she assaulted him subsequent to that, out of the same facts and circumstances. At one point, I'm not here to litigate the facts of that, but there were additional assaults by the victim here after that initial assault. He indicated my client stopped attending AA and the other counseling. It was
I'm gonna have to ask you to try and wrap up here.
I will, Your Honor. That it wasn't because he was trying to, as he indicated, look good for sentencing. He and his husband, they're gay males, were receiving death threats during this entire case. They had to relocate, renting an apartment in Cleveland, and there was a period of time during this 8 months that he was not attending because of the move to Cleveland, which at what time he did re-engage. So at this time, again, we would ask that you remand for resentencing, Your Honor.
Thank you very much,
Thank you very much.
counsel. Thank you. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of course will mail a copy of the decision to both of you on the day that it is released, and the opinions will also be posted on the Ohio Supreme Court website. Thank you very much. See, it wasn't so bad.
No.